I was very troubled that advocacy, even after the guidelines became advisory, was still stuck
Yeah.
in the boxes. Tell me the narrative, and then we'll deal with guideline issues, but give me a narrative here. And that's what I would tell everyone in a world in which a judge is supposed to take into account the totality of the circumstances now under 3553A. Give me the totality of the circumstances. Don't reduce this human being to boxes.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. I am so excited today to introduce a very special guest. Well, Mark Allenbaugh is here too. He's not special because he's here all the time. He's special in many ways, but our very, very special guest is Judge Nancy Gertner, who is a former United States District Court judge. She served from 1994 until 2011 in the U.S. District Court for the District of Massachusetts. And now she teaches class on sentencing advocacy at Harvard, among other things. She's very vocal about the issues that she's passionate about. And I just noticed that you, along with 149 of your former judge colleagues, had to apparently tell Pam Bondi that you're not deranged. So I think that's a perfect place to start, Judge Gertner. Why are you not deranged?
Well, I don't even know where to begin. And what we were writing about was that, quite apart from what Judge Hannah Duggan in Wisconsin did, and now I can talk about that, what she did or didn't do. The notion that she had to be arrested, handcuffed, perp walked, photographed. The photograph had to appear in the press. Kash Patel had to comment on it, and that Bondi then had to talk about deranged judges is lunacy. It would be unheard of for a drug cartel member, much less a federal judge. What usually happens is there's a summons, particularly if there's no emergency, and there was obviously no urgency here, otherwise they wouldn't have waited a week. They then ask the person to appear, and if the person has ties to the community, you know that they will appear. It's hard to imagine a person more tied to the community than a federal judge with her courthouse in that building. I mean, the whole thing was set up thuggishly for the purposes of intimidating that judge and judges across the country. And the letter that we wrote to Bondi was that, saying this was nuts. If there's anyone deranged, it is she.
Well, that's a great place to start. And there's a lot of things that I want to cover with you and in this time together. And I definitely want to talk about sentencing issues, but I want to stick with this Judge Dugan thing because this has been on Mark and my mind very, very heavily. That, along with also the Garcia Abrego case that we've been talking a lot about too, these deportations to maximum security prisons for ostensibly life sentences with zero due process. But I guess we'll put that aside. And just so people know what we're talking about, not everybody follows the news as closely as we would like them to. But this was a Milwaukee judge who was running her courtroom and had cases on the docket. And one of the cases that she had was a man named Eduardo Flores Ruiz, who was charged with, not convicted of, a domestic violence case. And I couldn't tell from my research whether it's a misdemeanor or a felony that he's charged with. I'm not sure it matters all that much, but he's not convicted of anything. So then what happens is there's a bunch of agents show up in her courtroom. And the first thing that I noticed, because I've read the complaint and the indictment, is, it feels like there's a lot more to the story here. These are not just ICE agents. There's six ICE agents, but there's six agents that show up, but they're from ICE, they're from FBI, they're from DEA, and they're in plain clothes. And they say they're in plain clothes because they want to keep things low key and safe. Anyway, so apparently they say we're here to basically take this person into custody. So they know he's got a court date and they're showing up to take him into custody. And there's a whole lot of things in this complaint that I thought were very interesting on its face that nobody's talking about. But just give me, I mean, I know you preface this by saying whether she's did something or didn't do something is besides the point, and I agree with you. But I also think that to the extent there's really no actionable crime here, or that this probable cause, this complaint on its face gives you pause, I would love to hear just generally what your take is on what they're saying happened and whether you see a viable federal offense. I got in a lot of trouble for this on the socials because I said, as I read this complaint, I don't think this thing makes it past a prelim stage or an indictment stage. But that's just the defense lawyer and me talking. What do I know?
Well, I think it's a very odd affidavit in support of the complaint, right? So it says that she accompanied this man out the juror door. And then it says he was in the public area. So,
Right.
my understanding, and I'm reading into it, is that he went out the public door, and he then went to the public area. He went out to the juror door rather, and then he went to a public area because he winds up in the elevator with the DEA agents on the way down. So,
Right.
I mean, when I read the complaint, and again, I don't know what the facts are. I mean, I assume there had been sort of a kerfuffle at the courtroom door. The affidavit says that she confronted the ICE agents, and that there had not been a determination yet in the building about whether ICE agents could arrest people outside the courtroom door. And in other courthouses, that's actually have been barred. Don't do that. If you stand at the courtroom, you can stand outside the courthouse, but if you stand, or in the lobby, but if you stand outside the courtroom, you could intimidate witnesses who may want to testify in the proceedings. So
Yes.
she came out and she confronted them. She told them to talk to the Chief Justice, because my understanding from the affidavit is that these issues about where ICE could be were being discussed. There hadn't been a settled policy. Then again, and I'm reading into this, she goes back into the courtroom where this hearing is to take place. And for some reason, it couldn't go forward. And she then takes the man out the side door, which also leads to the public area. And again, I'm extrapolating to avoid the scrum right outside the doorway.
Hmm.
I can see making that decision. Don't go out that way. There are people there. Go out the side, but go down in the public area. So it
Yeah.
wasn't that she was secreting him out of the building. He was going to the public area. Now, again, these are my reading of that affidavit, but it was a very odd affidavit.
Yeah.
It goes to my first point, which is this is something that needed to be investigated. This was something that obviously was not clear on the facts. And the notion then that this was the product of that investigation is
Yeah.
sort of lame.
Yeah. Yeah. Yeah, and I think you hit the nail on the head in terms of the other people that were in the courtroom that might have been intimidated because I mean, I have experience with domestic violence prosecutions, and judges want to go to great lengths to make sure that the alleged victims are safe and not feeling intimidated by anyone to be able to, show up and testify in court because that's a big problem in domestic violence cases. For whatever reason, the victims don't want to testify. Now, I don't know what the status was. I do know from this affidavit there were victims in the courtroom. I also know that people are aware that ICE are coming to the courthouse and arresting people. So I don't know the status of these alleged victims, but if they don't have status and immigration is hanging around the courtroom, that would be a deterrent from them ever coming back to court again.
Well, the New York Times actually reported today about what's happening across the country with ICE standing outside courtrooms and even courthouses to arrest people. So there was a story about a woman who had been, uh, uh, who had been knifed by her domestic partner. She was then taken off, she was then arrested by ICE. And so her accusations against someone else could not be litigated because they took her away. And in Massachusetts, we had the situation of a man who was up on charges, and the ICE agent was sitting in the courtroom. He knew that there was a trial going on. There was a jury trial, and instead he went to the front of the courthouse. And when the day was over, arrested the supposedly undocumented immigrant. And the significance of this is that if you are just taking people off the street and deporting them, victims don't have their day in court. Victims don't have their day in court. There's then actually not a finding of illegality of a crime, which would be significant because if these guys ever made it their way back to the US, it would be significant that they had been charged, convicted, and did time in the US and then came back rather than just were shipped out. So it matters that these cases are tried, that there be punishments. In fact, the US attorney in Massachusetts said when she was just sworn in, said, I've told ICE to let me finish my cases before you deport someone.
Yeah.
And that's a very interesting comment, right? Let me finish federal cases, but I don't give a damn about state cases. And the state criminal law is where something like, what is it, 90% of criminal enforcement takes place in state courts. So if you're undermining victims and witnesses, you're undermining a very important process.
Yes. And if they do get convicted and they are deported and they do come back, that gives federal law enforcement an even greater mechanism to punish them.
That's right. That's
So
right.
it makes very good sense. And think about just reporting crimes. If victims who don't have status here and how fearful they're going to be to even report an offense out there. So for these supposed people who love law and order above all else, it's very curious to me. And the other thing that's very curious to me, and Mark and I talked about this when it first happened, but if ICE is supposedly focused on all these terrible terrorists and the worst of the worst gang violent criminals, I'm like, this man who's showing up for all of his court proceedings as directed, that seems a little bit incongruent with that worst of the worst. They don't often respect, showing up to court dates, in my opinion.
Well, when you step back a little bit, so there's this category of people who are in the middle of criminal proceedings, and that's one category. But I want to understand why Ozturk, the tough student, was deported. There was no indication of violence. She'd signed an op-ed. I want to understand, why the two Columbia students were facing deportation. They too were, just uh, protesting. I mean, this really is not the measure of the violent criminals raping and pillaging our cities that Trump has described. These are people who are being deported for their views,
Right,
period, full stop.
right. And this idea of intimidating judges is absolutely, I mean, they did this to send a message. So if you have a crystal ball and you're going to read the tea leaves, where does this case go with Judge Dugan?
Well, and it's unless they can come up with more than they have in the affidavit, and that's something we don't know. I think it's an insubstantial case, and I would expect her to beat it. But unless they could come up with more, I don't know what the more is, but it was a very odd affidavit because it said she guided him out the jury door
Yeah.
to the public arena.
Right. And you're
So,
right.
uh,
They never lost sight of him. They were actually rode down the elevator
right,
with him, and he was with his lawyer, by the way.
right.
So, which is another interesting point. I can't wait to hear this lawyer's take. And then I guess when he got to the street, he took off allegedly, but
Right, but he would have taken off. I mean, so that's very interesting. I don't know what the rules are with respect to arresting him in the courthouse. I don't
yeah.
know that there are rules about that,
But it
but that
seems to
would have
me their
happened
whole
anyway.
it seems to me their whole case rests on he went out this door, not that door. And that seems, I mean, I don't know, you're the judge, but that seems like not a lot of evidence from where I'm standing.
Well, if I mean, if he, if she conspired to have him, go out the secret entrance, that would be different.
Yeah.
And even then, I'd want to know what the explanation was. But here, he winds up going down in the elevator with two DEA agents. So,
Right.
so at the very least, again, judging only from the affidavit, she was, he'd avoided the scrum in front of the courtroom, but nevertheless wound up in the public area.
All right. So now I guess, oh, go ahead, Mark. You've
Yeah,
been
so
muted
sorry,
the whole time.
I've been
Oh, my bad.
a little quiet. Judge, one of the concerns that I have about the Judge Dugan arrest and prosecution is the kind of the bigger picture. And as I'm sure you're aware, Carolyn Levitt, she's the White House press secretary. She was asked recently if potentially Supreme Court justices, if they did something wrong, so to speak, or that was, I guess, against the Trump administration policy, that they could be subject to arrest too. At least she did not affirmatively state that the administration wouldn't arrest them. The point is that there seems to be something percolating in the background here with the Trump administration, policy enforcement, and judges in particular, because that seems to be that judges is the last bulwark in our democracy that's standing in the way from a full-blown unmitigated dictatorship. And am I being too hyperbolic and too concerned that there might be something percolating here in terms of an actual policy to start essentially threatening judges, both state and federal, into towing the party line?
I think that there's an effort to intimidate the judges. I think that there's an effort to intimidate judges. So sort of start with the easy part, which is, there were four judges who have articles of impeachment pending against them in the House of Representatives. Trump has said that they should be impeached. These are judges who issued decisions with which Trump disagreed and Elon Musk disagreed. That is unheard of. And
Right.
and that threat that led to Justice Roberts saying something which he never does. I mean, he never said, he speaks, in a speech, or he speaks at the end of the year statement, but this time he issued a statement saying impeachment is not the vehicle for dealing with judges with whom you disagree. So that's one thing. And then, you wind up with the Hannah Duggan case. But as I said, the case in Massachusetts, just to give you a sense of this, where I arrested a defendant in the middle of the trial. The DA was furious and said this is wrong, this shouldn't be done. And the U.S. attorney literally threatened the DA and by implication the judge. We are going to go after anyone who obstructs.
Right.
Now, this is an administration who, as in the Abrego Garcia case, should know the difference between facilitating and obstructing, right? State court judges have no obligation to facilitate ICE activities. They are a separate sovereign. The 10th Amendment says that they can run their courtroom as they see fit. They can't stand in the way of, but they do not have to facilitate. So, and I think that this, what the Trump administration is trying to do is to try to make judges afraid that they're going to cross that line between I don't have to facilitate, but I can't obstruct, and make judges afraid. Now, we have seen no indication that judges are being afraid. I have to admit, I mean, I've been afraid. The courts have held held to the line of the democracy in a way that is really quite stunning. So, I don't, I mean, but it's clearly efforts to threaten. And I think the Supreme Court statement is saying, well, if the Supreme Court crosses the line, we'll go after them too. Well, what is the line?
Right.
What is the
Right.
line? The
Right.
Duggan case suggests that, we're not sure what the line is.
Well, there's another issue here, and beyond judges being unafraid and fearless. So we have these judges that are, standing the post, and the guardrails are holding in a lot of these cases that are being brought, and the rulings are being made that these certain actions are unconstitutional, and orders are being put in place. And it looks to me like the other strategy besides intimidate the judges into not ruling against them is, if they do rule against us, so what? I'm not following your order. What are you going to do about it?
Well, that's
And
not,
that
yeah, that's the
and that
part we don't know about yet.
Well, isn't it kind of happening in the Garcia Abrego case where, turn the planes around? No. Facilitate his return? No. These are the things. So I want to know from a federal judge's perspective, when a litigant before you says, "Yeah, that's a nice little order you just did there, judge. Go pound sand. I'm not doing it." What happens? I mean, that's the full-blown constitutional crisis that we all worry about, but to what end? What's the remedy?
Well, not with respect to Trump, but with respect to the officials carrying out his order in the judge's courtroom. They can be fined. They could be cited for contempt and as you know, jailed until they purge themselves of the contempt, until they follow the order. And they can be subject to criminal contempt. Now, the issue with respect to criminal contempt is that the Department of Justice is the one that would bring criminal contempt charges, but the judge can appoint a special prosecutor.
Yeah.
The case, the Donziger case, right? The lawyer who was supposedly was charged with, who was attacked by, I've forgotten the name of which oil company. Do you know the case, Stephen Donziger case, that you know which one I'm talking about?
Not ringing a bell for me.
Not ringing a bell.
I could Google it.
I'm doing it right now. Here we go. So just a second.
Chevron,
right. So he received an enormous award in Ecuador, again, when he sued Chevron. When he came back to the United States and tried to enforce it, Chevron filed a RICO case against him. And there was an issue of his turning over his computer, and he didn't want to turn over his computer during the course of the case because it had client names on it. He wound up being placed on house arrest, awaiting charges of criminal contempt. The judge appointed a special prosecutor rather than using the DOJ's regular prosecutors.
and why was that? I'm sorry
Well, it's not clear. I don't know exactly the reason why. The judge, in that case, it was not. It's conceivable that the DOJ didn't want to bring the contempt charges, which would happen now. Let's say there is a official who could, with a phone call or carrying out Trump's orders, could call Bukele, the El Salvador, chief, and say, bring Abrego Garcia home, and they're not doing it. So a judge could assign fines for every day that they don't make that call, put him in jail for every day that he doesn't make that call, or bring charges of refer to criminal contempt, and the DOJ then would have to make a decision. If the DOJ says we're not going to enforce that, then you would appoint a special prosecutor, as in the Donziger case. And the special prosecutor would bring the charges.
Yeah.
I'm still wondering who enforces that, who goes out, arrests a person, and puts them in jail for contempt or collects the fine.
Marshals, U.S.
Yeah, the
Marshals.
U.S. Yeah.
But who aren't the U.S. Marshals under the
Department of Justice?
DOJ?
Yeah.
Well, that's what I have to admit. There's a question I've been asked many times. That's not taking away from your creative questioning. I just want to make that
Yeah.
clear.
Is it not? Am I wrong?
No, it is the Marshals, but the Marshals, actually, the authorizing statute for the Marshals talk about the language is shall protect judges, among other things. And so they could well feel, if the DOJ says, I'm sorry, you cannot enforce this criminal contempt order, this civil contempt order, there's at least an open question whether they would be violating the terms of their own oath and the authorizing statute. Now, if you want to go down this rabbit hole, who would enforce that?
Right.
The answer is I don't know. We're not there yet. What we have
Yet.
seen so far is the Department of Justice, in bad faith, in my view, parsing what they have to do. The reinterpreting the Supreme Court decision, which said facilitate his return, and really just playing word games, in my view. That will end, it looks like, in Judge Boasberg's courtroom, because he has the case involving the Venezuelans, that the first plane load of Venezuelans who were sent to El Salvador. Let me just say something which has escaped all the discussions that I participated in.
Yeah.
My understanding, and I may be wrong, that El Salvador prison is effectively life.
Yeah.
Yes.
It's effectively
Yeah.
a life sentence.
Yeah.
And whatever the people who have been sent there have done, life sentence is something they would never have gotten in the United States, nothing
Right.
that our system would allow.
Yeah.
In addition, I understand, and again, just from reports, there's the sort of regular use of solitary confinement.
Yeah.
This
is one of the most notorious prisons in the world.
Right.
In
This
terms
is
of
a
the
prison that would
conditions of
never
confinement.
meet any of our Eighth Amendment standards.
Right.
So
Kind of like the Bureau of Prisons,
Yeah.
which
yeah,
doesn't
well,
meet our standards either, but
right,
that's
but-
another
Right.
story.
but that's right.
Well,
They don't meet to some degree. This doesn't
Right.
meet at
Right,
all.
right.
And
I was
it's
being
forced
facetious.
labor. I just recorded a podcast. It hasn't dropped yet, but with an investigator who does a lot of his work in El Salvador, who knows this prison very well, and he's described it. And it's everything you said, Judge,
Yeah.
and also forced labor. And, not for nothing in terms of echoes of the past, deporting someone to another country. If they're not here legally, deportation, I understand, but deporting someone to a foreign country to spend possibly the rest of their life
Right.
in a prison camp,
Yeah.
labor facility, I don't like the sound of that on a lot of levels.
Well,
And
after
you're right, we're
9/11
not talking about that enough.
Right. After 9/11, this extraordinary terrorist attack on American soil, the people in Guantanamo had rights and hearings. The issues, even the secret torture places in wherever the CIA had taken people, wound up being litigated in some fashion in the United States. You think about that period of time, there was law even in the dealings with the people we suspected of having something to do with 9/11. There is
Right.
no law here. There's
Right.
no law before they're deported, and there's no law, it's apparently, in that prison.
Right. And we don't know who else is there and whether there's any other U.S. citizens. These people have no access to attorneys, no access to their loved ones. It's egregious on every level. What were you going to say, Mark?
Well, I just, since the judge brought up sentencing, I'd like to just segue there, if we can, in light of something that occurred this morning that I think is pertinent and relevant to what we've been talking about. And to back up for a second, this has to do with the new pardon attorney. January 6th, we had over 1,000 J6 defendants prosecuted by the Department of Justice. Most of them pled guilty. A few of them went to trial. Significant sentences were handed down for many of them. All of that, once Trump took office, nobody, well, at least I didn't think, I thought it was hyperbole that he was going to pardon all of them. He pardoned all of them. Mm-hmm. And I think that was, in a sense, that was also a slap to the judiciary, especially the judges there in the DC District Court, that effectively just overruling all of the work, all of the prosecution. And now he's been going after, or some of his minions have actually been going after prosecutors that prosecuted those January 6th defendants. This morning,
and apparently,
and FBI agents, Ed Martin, who was the acting U.S. attorney for the District of Columbia and was very, very controversial, Trump withdrew his nomination to become the U.S. attorney in the District of Columbia. And because one of the senators, there was a whole holdout senator that just thought he was too crazy and was not going to nominate him or block the nomination. He ended up, what Trump did is he withdrew Ed Martin's nomination and is now making him the pardon attorney. And
Oh,
I
I
haven't,
didn't know that.
yes.
But by
And
the way, do you know who he's replacing? Who's up for the nomination now?
Judge Jean, Jean Pirro,
Because Ed Martin was apparently too crazy for the
too
job, so
crazy.
we
Well, he
needed a.
wasn't crazy enough,
Okay, good.
apparently. But I think,
Cicely Strong is going to get reprise her role on
oh yeah,
Saturday Night
she's
Live
coming
very
back to
soon.
SNL with this for
Anyway,
sure. For sure. So, Judge, my question, my question and my concern is, we talk about sentencing. This is our lives, and this is what we do. Now, with somebody like Ed Martin as the pardon attorney, I think shouldn't we have to fear that something like January 6th is now going to be the policy of the Trump administration, that if you happen to vote for Trump or you happen to be a Republican, you're going to get off scot-free for any federal offense, or you could if you donate enough money or something like that, because we know he takes bribes and all these other things, or if you invest enough cryptocurrency or something along those lines, you'll get a pardon. George Santos, Doug and I just did a podcast on George Santos sentencing. I think, what was it, Doug, like 84 months he got? It was a pretty
hmm
significant sentence.
yeah.
It looks like he's going to get a pardon from Trump. And he's been lobbying hard, and he probably will be able to get a pardon from Trump.
By the way,
Um,
Judge, we paid George $100 to do a cameo intro to our podcast episode
yeah, it was hilarious.
and calling us armchair quarterbacks and
Yeah.
Monday morning, whatever. Anyway, go ahead.
So,
Yeah.
so anyway,
Well,
so
he
my
probably will get a pardon if he can find a lawyer that's connected and pay enough money to get it done.
so what do federal judges do if we're supposed to have this system of equal justice, et cetera, et cetera, et cetera, and have the guidelines with, despite all the problems. I'm not even going to get into that stuff, but just that now, what are federal judges to do when they're imposing sentences if they know, or there's a strong suspicion that the defendant in front of them, regardless of whether they committed a violent offense or an economic offense, or if they're a recidivist or not, regardless of any of that, what if federal judges to do if they suspect that this individual is most likely going to get a pardon? Or is that not an appropriate consideration?
That's not an appropriate consideration.
Okay.
Trump's discussion of pardoning the January 6th defendants was in the air when some of the judges already sentenced them. They did what they did. One of the things they did, however, was in many cases, they were very clear about what these men were being charged with and what they had pled guilty to. And so you found very, very sort of robust explanations about what they had done and why the judge picked the number that they did, why the judge sentenced them, which was very important because they did not want the pardons to wipe out the narrative. The narrative of what they had done was very important. So I think that that's what would happen now. Trump can pardon whomever he wants to pardon, but the judges will sentence the way they think is, as they think it's appropriate, and say why. And that why is part of the historical record. And I don't think you should, discount the significance of that historical record. So no one could look back on this and say these were tourists who just wanted to see the Capitol, when
Right.
the judges were talking about what it is they agreed that they had done, or the juries had shown they had done. So I thought that was really important. And I think that will continue. You stay in your lane, and this was staying in the lane, but making it clear what the why was.
Right.
Well, and I think what breaks my heart about this is that I will have inevitably clients who have done things that may be on par with that bad behavior of 1716, or maybe they're fraud clients who I know aren't going to have the money or the political connections to finagle a pardon, and they're going to suffer while these other people walk free. Liz Oyer has now a podcast or a TikTok, and I've been following her, and she points out there's been about $1 billion of restitution owed to victims of fraud offenses that have been wiped away as a result of these pardons. And so you have
Wow.
one class of offenders that have zero consequence for their conduct, and then you have other class offenders, usually the ones with no money or who don't look or have the same background as, people in power, who are going to suffer the brunt. And judges should rightly concerned with sentencing parity.
Right.
But I know that at the end of the day, no judge is going to take into account that these people walked free under a pardon when they're dealing with my guy's sentence. And
No,
that's really it just feels
I mean,
fundamentally undercuts the whole system of
well,
justice.
apart from even the January 6th people, I mean, the people that Trump pardoned in Trump 1 were people who, by any other measure, would have gotten, would never have been pardoned. I mean,
Right.
and so we don't take lessons from that. Judges will do what's appropriate in any given case.
Right. Yeah. Nothing's normal and everything we knew is upside down and I'm feeling very unmoored in the way that I'm representing clients and approaching the cases and approaching U.S. attorneys and everything else. And I'm just wondering, what help me ground me. And do you think there's any hope that the downstream prosecutors aren't going to get completely swept up in the insanity and will still hold the line and try their best to do business as usual?
Well, it's hard to say. So I think it depends on what the nature of the crime is. So you're seeing drug crimes being litigated as they had been before. You're seeing immigration offenses, although the tripwire to be deported is different. You're presumably seeing white collar offenses that don't involve the Trump administration being litigated as they had been before. Although my understanding is that the number, I only know the District of Massachusetts, the number of indictments in Massachusetts has declined precipitously. So the question is whether there will be one justice system for anything having to do with the Trump administration and another justice system for the rest of us. And that when you say, how come my defendant got the book thrown at him when the January 6th defendants were pardoned or other white collar offenders were pardoned? I mean, that's a reasonable thing to ask, but a judge is likely to say those are, as we say in the law, sui generis. They are unique unto themselves, and that won't affect the rest of the criminal legal system. So, so to the extent that you want to argue, look what happened to so and so. How come my guy is getting a worse punishment? You can argue that, but I can't imagine that a judge would say the Trump examples are examples for the whole system. There's no reason why they shouldn't be, but it's not likely to be. Now, to the extent that you need therapy, that's a different issue entirely.
I need a lot of therapy.
No,
Mark
I
can
mean,
attest to that.
I guess, I mean, I think there are still line prosecutors that are doing the usual stuff that line prosecutors have done under other administrations, even though the top and supervisors have been changed. But, I think that will continue. But your point that you want to compare the way the ordinary defendant is being treated with the special treatment for the January 6th defendants and others who have been pardoned is a fair point.
Yeah.
But I can't imagine a judge would say, just because this president has been lawless, I should be lawless.
Yeah. Right. All right. Well, let's draw a line because I know I probably don't have you endlessly and it's Friday afternoon. If it were a little bit later, I'd be drinking tequila, but it's still only 2:50 here. Usually I do a tequila tie-in with this podcast. But anyway, that's another story. I feel like after this conversation, I definitely want to drink. But it's the whole reason I created this podcast, and there's, 110 episodes so far, and it's to bring more awareness and more fairness and more humanity to this process. And so while I've got you, you've seen a lot of people be sentenced and you've seen a lot of lawyers. You've seen good lawyers conduct really powerful and effective sentencing proceedings. And I'm sure you've seen some not so good lawyers. So first question is, I'm a brand new lawyer sitting at your feet, Judge Gertner. What is the best, I don't know, 3 pieces of advice you can give me for how to most effectively represent my client at sentencing?
I know that the guidelines are the guidelines and are advisory. But the day after the guidelines became advisory, I had an uncharacteristic murder case. And the lawyer got up and said, Judge, now that the guidelines are advisory, you can reduce the guideline score by 4 rather than 3. And I leaned over the bench and said, why did he do it? Tell me a story. Tell me the story of the crime. Tell me the story about the man accused of the crime or the man convicted of the crime. Tell me the narrative. And then we'll deal with guideline issues, but give me a narrative here. And that's what I would tell everyone. The narrative serves numbers of purposes. In a world in which a judge is supposed to take into account the totality of the circumstances now under 3553A, give me the totality of the circumstances. Don't reduce this human being to boxes. And that's what we've gotten into. Advocacy has to change. I mean, I was very troubled that advocacy, even after the guidelines became advisory, was still stuck in the boxes. Hey, judge, you can consider acquitted conduct. Well, let's pause for a moment. Why? In what universe is that appropriate? Hey, judge, I had one case that I actually write about was before Booker, but the government argued that there was a pending firearm charge. And I said, gee, I know I can consider that, but why should I? It hasn't been adjudicated. Why should I do that? Or, so to give me a narrative and see if you can get out of the boxes that essentially take away the humanity of the defendant and even take away the nature of the crime. In other words, it is bad for victims as well, because you have completely defanged the crime. The crime becomes, number X and number Y. I mean, becomes number 5 and number whatever. It doesn't either convey the richness of the offense, and it certainly doesn't convey the humanity of the defendant. So tell me a story.
Yeah. I love that, because that's where I live and breathe. And I don't know if you know, but the sentencing mitigation videos have been my thing for a long time. Well, first of all, I'm glad that the guidelines are advisory, because it's been 20 years, but Mark and I still see these
Oh
pleadings,
God,
these
yes.
sentencing memos where the
Yeah.
first 2 or 3 pages are about Booker and Fan and the discretion and the bleep blop bloop, and I'm like, man, if a judge doesn't know this after 20 years, but it's just a lot of wasted space.
Up until I think recently, I track how the Sentencing Commission teaches sentencing. There are something like 35 or something like that slides, 34 of the guideline calculations. 35 says Booker. Thank you very much.
Oh, fair point. Yeah.
Wow.
So the judge has absolutely no idea how to exercise their discretion. And then when I speak around the country, there are guideline jurisdictions. There are guideline jurisdictions that, to all intents and purposes, Booker hasn't happened.
Wow. Jeez.
Which is, it's why I call this studio 3553. But push the guidelines aside. That's everything. And when we're talking about tell me a story and the nature, I literally had this very fancy, highfalutin defense lawyer say to me, I'm not talking about the crime. He had a little catchphrase, little Johnny Cochran-esque catchphrase. He goes, if I'm talking about the crime, I'm losing every time. And I'm like, really? Like, you're just going to let that narrative be untouched then? Okay, I get it. So, well, see, speaking of storytelling, I feel like there's no better way, in the right case, not every case, to tell the story is through a sentencing mitigation film. As I said, that's really my bread and butter. And I wanted to get your take and how your colleagues feel about these as they become a little bit more common, and we're seeing, especially in federal court.
Well, first of all, can you send some to me?
Yeah.
We teach judges. I have them come to my class, and the Federal Judicial Center and the Center for Law, Brain, and Behavior teach judges about addiction and trauma and other things. And you teach based on a cold record, right? I mean, I just have hypothetical cases. I'd like nothing better than to have a person. And because there was always a difference between sentencing on the cold record and walking into a court and seeing the human being. And there should be a difference. Sentencing videos were not common when I left in 2011. I don't hear that they are common in Massachusetts either. I know that some judges were concerned about the resource problem, which is public defenders don't use them. People have means to have the ability to do it. And so if you run the risk that you're sort of crediting something which poor people won't have access to. And
Well,
I think,
I wish I could speak to the judges right now, and here's what I would tell them. This method of advocacy was born and raised in the federal public defender's office.
oh,
Uh,
interesting.
I did my first video in 2004, I think it was, and I was a federal public defender in Phoenix, and John Sands was my boss and my mentor. I remember the first day I came into the to work, I was clerking and studying for the bar, and he came with an old dime store book, used book of Gideon's trumpet, and slapped it on my desk. It said, "Read this, kid." And then it was about the Navajo and everything. But he loves outside the box advocacy. And when I did this video, I don't know that anyone else was doing it. I'd like to say I'm the first. I'm probably not, but that's my story until someone proves me wrong. But he jumped all over it. He sent me to film school. He had me train 3 paralegals in the office to do editing. He set up a little studio in one of the spare offices with all the computer equipment, and he sent me around the country to speak and train other federal defenders. And so, more, I would say, if you did a survey of all the sentencing videos ever submitted in federal court, the vast majority of them are coming from indigent clients.
Well, that's
And
interesting. And the
judges
court
need
is
to know
paying,
that.
and the
Yeah.
court is paying for that?
Well, if it's coming from within a federal defender's office, they're in control of their own budget. If it's a CJA case, it's a little more difficult because judges are still reluctant to give a whole lot of funding for that kind of thing.
Right.
So that's been
Yeah,
a
I
little
mean,
bit of a tougher nut to crack, but I mean, people still do CJA cases too.
well, as I said, I think anything that contributes to the narrative is a good thing. You know, tell me, as I said, tell me why you did it.
Yeah.
I remember when I was a criminal defense lawyer, it was pre-guidelines. I mean, I had the guidelines, I got on the bench in 1994, and although the guidelines were passed in 85, they were not, I mean, I was still doing much of my practice in state court, some in federal, but mostly in state court. And in state court, you could say, let me tell you about this man. Let me tell you about this. Let me tell you what he had to go through in his life. And here's to the extent we can explain the crime, here's the explanation of the crime. And here's what I propose we do with him, what we can do to address his issues. But it was a narrative, and the sentencing guidelines changed judges, changed changed lawyers, changed advocacy. And we have to learn to undo that.
I'm so surprised we haven't learned it after 20 full years of
Yeah.
discretionary guidelines, but you're right. So I
But
asked you,
not only 24 years of discretionary guidelines, but also virtually no one is being reversed. Virtually no, if you calculate the guidelines pretty much as the government wants, you think it should be up 5, it's up 5. I mean, judges don't want to even deal with the calculations because the only grounds on which you are reversed is if you haven't calculated the guidelines. So it should have been a moment of immense creativity because you had very different when I was on the bench between 94 and 2005. Although, Mark, we can both confess to this. Mark, Sentencing Stats, did an analysis of my sentencing. And the pre-Booker period was indistinguishable from the post-Booker period.
oh, wow.
So much so that they thought there was something wrong with the statistics.
Yes.
I don't think I could not have been more pleased.
Yeah. Yeah. You were already sentencing under Booker before Booker was cool.
Well, how does that work? Just downward
Departures.
departures? Just
downward departures with
downward
with an explanation,
Right.
I mean, I was teaching sentencing, and so I could say, here's what the downward departure was intended to accomplish. Here was what people said about it, what the sentencing commission said. This doesn't fit into that category. And yeah, I most of the time the government didn't bother to appeal.
Oh, if only there were more Judge Gertners in this lifetime. Our job would
Yes.
be so much. I wouldn't need half as much therapy as I need. Well, so I asked you the question about the best tips from a baby defense lawyer standpoint, and that's great advice. Now I'm a defendant, and my big day is coming, and I'm scared to death, and my lawyer hasn't really given me great advice. So, Judge, what am I supposed to do? What's going to move the needle in at sentencing?
Um, if your lawyer is not advocating for you, I'm not sure what would. Judges will say that the allocution, the statements of the defendant will move the needle. When you're on the bench for a long time, you understand that oftentimes those statements are contrived.
Mhm.
And that in fact, this is an overgeneralization, the most culpable, the most in charge, the most, in charge in control of what they're doing, have the best allocution because they are articulate, they know the buttons to push. Oftentimes, the least persuasive is the person who, is not particularly articulate and can't communicate his pain to the judge. And you have to sort of have the filters so that you know that the perfect allocution may or may not have been, may have not have been honest, that the least perfect allocution could have been honest. And then I might add, in general, now as an academic, statements of remorse in general don't affect recidivism, and it's not clear to me that we even can distinguish what's real remorse from what isn't. But that's what people say. Certainly a defendant who shows his humanity, if will make a difference. That will make a difference. I'm collecting the cases in which the guideline sentences were in the stratosphere, and a judge decided to take a chance that worked on someone. There's a wonderful story of a bank robber that was totally and completely addicted. He had multiple bank robberies, but they were not Italian job bank robberies, right? He would walk into a bank, desperate for a fix, stick his finger in his pocket, say, stick him up, walk out, cut with money and covered with the die pack. And then he'd
Wow.
up, he'd go to prison, he'd use in prison. That was clear. He'd get out again and do the same thing. He finally gets out in his 60s. He winds up getting into a program, post-conviction, post-sentencing, post-prison program. And something seems to click and something seems to work. He has a wife and a family. He has a job. And it works for, I don't know, some period of time. Then something happens and there's a reversal. He uses again. He walks into a bank, does the usual thing. The judge in the case and in the judges that I train said, what do I do? Which is the person I'm sentencing? The person under the guidelines who's in the stratosphere of guideline calculations with multiple bank robbery, or the person who finally got the help he needed and it made a difference? And this judge was terrific. What she did is she put off sentencing for a year to give him another chance to get back on.
Wow.
And he did. And she sentenced him to time served.
Nice.
So I
Yeah.
try to tell the stories of, here, this is a case that you should look at. Do you have a defendant with those kinds of characteristics who could succeed no matter what the crime was?
hmm
No matter what the guidelines say.
And that's a creative approach that a lot of defense lawyers wouldn't even think to even, the judge
Right.
did it on their own, but why wouldn't you just say, Judge, give him a year. Let's come back here and see if
Right.
he's put his money where his mouth is. And also tell the story of why he relapsed that last time when he
Right, it
was
was good.
doing so well.
Addiction specialists will say that, just giving up the drug cold turkey doesn't actually address the ways in which the drug rewired your brain.
hmm
And if you don't actually get therapy, it could be talk therapy more often. It's now medical assisted treatment. If you don't address the way in which the brain was rewired, you will relapse. And it's not a question of you're a bad person. Some of the addiction specialists that speak to my class will say, we no longer we no more criticize someone who gets a relapse of cancer than a relapse of drugs. If anything, the powerful rewiring of the brain makes relapse likely if it isn't addressed. So we have to start thinking about all of this differently.
And by the way, that first sentencing video that I was telling you about, I did in an addiction case. And it was a young man who was deeply, deeply addicted to methamphetamine and completely changed his life. And that's what motivated me to do the video because this was a story that had to be shown and not told. And the minute I knew that is when he told the story of seeing his mom for the first time after he got arrested and was in jail. And she was from out of state. And he called her from jail to make sure she knew he wasn't dead. He was in jail, and she hadn't seen him in a couple of years. She said, "I'm coming to visit you." And he said, you don't want to do that, Mom. You don't want to see me." And she said, "I'm coming." And he described the day, visiting day, when all the inmates were shuffled in on one side and all the visitors were shuffled in the other side. And his mother, he laid eyes on his mom, and his mom laid eyes on him, and she immediately turned away. And his heart sank because he said, "She's so ashamed at how far I've fallen, she can't even bear to look at me." But then he said, "I kept looking at my mom, and what I saw is she looked at another inmate and looked away, and she looked at another inmate and looked away." And what he realized was mom didn't recognize him when she laid eyes on him the first
Come
time.
on. Wow. Mm.
And so we had that booking photo of the skeleton, the shell
Oh,
of the
geez.
guy that he had become, and then this juxtaposed with a year later, and he didn't just go through rehab; he was the star of the facility, and he had totally transformed his life. And not an easy sentencing judge here, and the guy got probation, and that's when I knew we were on to something there. Well, I have one big other question. Well, I have a lot of big other questions. Let me tell you something. I don't know if this is gonna make your head spin like it did mine. And Mark, have you seen this out here in Arizona? This is just a story from a day or two ago. It was a road rage shooting where a victim died, and it was a guy who got convicted of manslaughter. The victim's family did an AI video
Oh, I heard about this.
of the deceased victim, this man, to
Ooh.
present in court as to what his position would be from beyond the grave. And
Oh, wow.
and and the judge said he loved it and he was all up for it. And my my head just exploded. First of all, if I did that as a defense lawyer, I'd probably be cooling in a jail cell right now.
Right, right. Yeah, no,
Is this the bleak, dark future? The waters that we're gonna have to swim in? Like, would you have been a million years allowed this to
no,
happen? I guess the
no,
victims have more leeway, but still,
no. I
it's
wouldn't.
not.
I mean, the until we until we understand the ways in which AI is contrived, what the algorithms are, I mean, I wouldn't trust that. I mean, you know, I have my own opinions about AI, but I hate to pronounce them because they seem to be coming from, an elder statesman, and of course she would say that.
Yeah.
Uh, but Mark will tell you that I'm actually a techie. I am
Yes.
on every platform. I love to play around with the computer, and my feelings about AI have to do with more the extent to which we lose control of the narrative, really, when you cede it to a machine.
Right.
That's what I worry about. And that goes to both judges that are, that and no one is using it now, but who would use AI. If I could feed in some of my decisions, some of my written opinions to Chat GPT, and I would say write an opinion about, sentencing Mark Allenbaugh, and I'm sure it would come out fabulous. But all the steps, all the judgments that you make when you write would be gone. All the nuance that you
Mm.
think make a difference would be gone. So I'm skeptical of the whole project, not just because of my age, but because of my deep wisdom.
Yes, well, I share your skepticism. Well, before I wrap up, because I do have one very good question I want to ask you, but Mark, I don't want to put baby in a corner over there. You dressed up in your beautiful turtleneck and you look so handsome and you've just been seen and barely heard. So I want to make
Mhm.
sure Mark and I are good pals, so I could
Yeah.
tease him with this. Judge.
Yeah.
Just so you know, I'm not
Well,
being a
the
total
one,
condescending a-hole, but what questions what did I
well,
miss?
I mean, I have one last question. As we know, Justice Souter passed away this morning, and I'm just wondering if you have any thoughts on him on the bench, what his legacy will be with respect to sentencing. As you probably know, he wrote an opinion back in 1992 when he was on the Supreme Court, that kind of foreshadowed Apprendi, which foreshadowed the end of the guidelines as a binding project. And I'm surprised nobody has, nobody took that case and from 92 and made it into Apprendi. It took another 13 years to get to Apprendi. But at any rate, just wondering what any thoughts you have about Justice Souter and his legacy.
First, I have a confession to make. I sued Justice Souter.
Oh,
Not when he was a justice. My husband and I were representing 1,400 demonstrators at the Seabrook nuclear power plant. Souter was the attorney general. The suit was that the government was using bail for the purpose of punishing the demonstrators. In other words, rather than giving the people a summons to appear later, which had happened in previous demonstration, suddenly they were imposing money bail, and very few of these kids, they were mostly kids, had a dime with them, so they were bound to spend some time in jail rather. And so we sued. I think we sued the governor and my husband took Justice Souter's deposition. We won and lost. We won in the sense that people were released after 5 days of detention. We lost the case ultimately, but actually we mostly wanted them to be released from detention.
yeah.
Souter and I were friends. After that, whenever I tell this story, when I would tell the story in New Hampshire, he would invariably get up and say, "I won." He was really a very interesting human being, and I mean, extraordinary humanity to the people around him, lived very modestly, and didn't feel that he had to follow a Republican script.
Yes.
Very
Yes.
much like that, he was his own person, and he would see things as, the way he thought they should be seen and not feel he was beholden to anyone, which is why his record, is criticized by the MAGA Republicans now.
Right.
But as I said, he was very decent and warm human being, adored New Hampshire, and would go back, didn't love Washington so much, but he was a good man and with considerable humanity, and we are much diminished by his loss.
Thank you. Yeah.
Well, I'm remiss because I should leave it there, but I won't because I don't know. This thing has been on my mind because when we do sentencing advocacy, one thing that we always are very careful to do is to tell the story of prison at sentencing, because as I'm sure you know, the state of the BOP is probably worse than it's ever been in its history. It's dysfunctional, it's dangerous, it's dehumanizing. There's no health care, there's no psychological care, there's very little programming. In some of these institutions, it's a complete free-for-all. And, I guess I'm really interested to know, because I've actually had a judge here and there go, give me my name's Paul and that's between y'all situation, which is like, that's the BOP, that's the executive branch. I don't control the BOP and that's not my problem and I'm not considering that. And I guess I want your take. Like, is that something judges should consider? And are they really aware of what happens to these human beings after they leave their courtroom? And do they care? And should it matter as a sentencing consideration? Especially for an older person with medical needs, a person with mental health issues.
In my course, I teach sentencing at Harvard. We have Walt Pavlo from Prisonology come and speak.
Yeah, we know it well.
And talk about the disconnect between the First Step Back and what Bureau of Prisons are doing. We have him talk about the drug program in the prisons, which judges will say, "I'm going to sentence you to X time. You will be in the RDAP program, drug program, and that will help you." And I did some research into the RDAP program and would say to these judges, that they admit very few people. that in fact they largely admit people, they narrow the criteria, so it's only people who are likely to succeed. There are some articles that suggest there's a racial component to who gets accepted. And so if you're sentencing on the understanding that someone is going to be getting in the RDAP program, think again. So to your question, do judges know what goes on in the BOP? No, we know what the ideology is, we know what the image is, but we don't necessarily know what actually goes on. And that should be part of the sentencing calculus. A judge can't affect what the Bureau of Prisons does because that's an executive function, but a judge could take it into account. In what I did this when I departed downward when I was on the bench in the case of a man who was not a citizen. And I found out, again, not because the lawyer told me, but because I found out that that would mean that he wouldn't qualify for any programs while in prison. Yeah. So I lowered the sentence that the guidelines then required because I said his time will be different than anyone else's time. So no, judges need to know what happens in prison, what the chances are that he'll wind up on the other end of the country when his family is in Boston. You know, what's the kind of program that he's likely to get, GED and likely nothing else. If he's ill, what's that going to mean? What's the nature of the care? There was just an article about Devens which is supposed to be Fort Devens, which is supposed to be a medical facility, and about the inadequacies in medical care. No, judges need to know. Even if they can't affect those conditions, they can take it into account in their sentencing.
Yeah. Well, I'm glad to hear you say that. I hope that when you get to speak to the judges, you tell them, because I don't know that well, first of all, I don't know that lawyers are understanding these issues and presenting them, but when we do, sometimes they matter and sometimes they just don't.
But that goes back to what we were talking about before. The guidelines have changed the way lawyers advocate.
Yeah.
That the notion that you even have to look into what's going on in the Bureau of Prisons is innovative. Shouldn't be, but it is innovative. Just as you need to find out something about the family, even though up until 2005, family circumstances were not to be considered. So what happens is that the history of guideline advocacy so narrowed the view of most lawyers that the judges are not getting the full picture. We can go on.
Yeah.
I'm waiting for the margarita time.
Yeah. Well, it is. Yeah, I know it's late on the East Coast too, so that may be a good place to start, but I hope we can do this again because it was so amazing to have you and your insight, and we covered a lot of topics. So Judge Gertner, thank you so much for being here. And, you know, if Pam Bondi's listening and she hasn't read the op-ed piece, she needs to know that you and 149 of your former colleagues are not deranged. And you have proven that in perpetuity today. So I just say thank you again. And Mark, thank you for facilitating this. And thank you for being a good sport while I pushed you into the corner and silenced you into relegation. But you look good, and that matters.
That's what matters. That's all that matters.
If anybody's listening on the audio, they need to go to the YouTube so they can see how good you look.
Oh, thank you.
Thank you, Doug.
Okay. Yeah, thanks, Doug.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassenlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.